Uh, can we start? Have you admitted? Achha. रिकॉर्ड तो हो ही रहा है ऑलरेडी. मैं कर दूं start? Okay. A very good evening to all of you, people who are joining us here in person as well as people who are joining us online. Now we are into our second session, which is going to be on the RTI, and it is rather an important topic. And a lot of you who are from the university or not from the university, you would already know that Mr. Joy Chanda is the Joint Registrar here at the University of Delhi. So obviously that's one introduction that is important, and the fact that he's looking after academics, council and information here at the University of Delhi. But I think there cannot be a better introduction to him than the fact that when the university is in its centenary year, in celebrating its 100 years, it is Mr. Joy Chanda who's been entrusted with the administrative responsibilities of whatever that would go on in terms of celebrating, in terms of archiving, in terms of in every sense of the word, as to when we think of, you know, celebrating a centenary of a university like Delhi University, that's a humongous task that I think Mr. Joy Chanda, someone like only him, perhaps can undertake. So that itself must tell you as to what kind of responsibilities he is handling right now at the university. But in case you're wondering as to what is his connection to this topic today, which is the Right to Information Act, so it is because he has previously acted as CPIO and the first appellate authority of the University of Delhi. So you can understand a university like Delhi University gets all kinds of RTI applications, which are quite challenging. I'm sure you can appreciate that. He is the man who has been for a very, very long time, I think almost 10 years, who has handled it and have then further mentored people who later took this responsibility. So there is so much to talk about him, but I don't think I would keep you away from your speaker by taking a lot of time. I think what I would really like to mention also about Mr. Joy Chanda is that he is not only someone who knows his rules and regulations. He also has a penchant for language and writing, and he is certainly looked at as someone who, one of the peoples who writes very well, and therefore many people look up to him in terms of asking for suggestions and generally asking him and taking his advice on matters. And I don't think I'm exaggerating at all in this matter. So Mr. Joy Chanda, you're most welcome here. And I'm sure you will make rather a dry subject an interesting one.
Namaskar. Good afternoon, rather good evening to the participants who are joining offline before me, my colleagues and also colleagues from other institutions, and the participants who are joining online. So I think for me, this is the first such session I'm taking in a blended mode, because I did take a few sessions which are online and offline definitely prior to the pandemic situation. So it's a new experience for me as well. You people have already attended many, so maybe it's an old thing for you. Now coming to the topic. I've been given a topic which reads RTI, its origin and growth since 2005. If I may say so, that right to information as an act came into being in 2005. But discussions and public discourse on right to information initiated as late as early as 1977 onwards. There have been efforts actually to put things in perspective. And if we really see a concretization of the endeavors which have been done in this direction, so we will see that there is a Freedom of Information Act in 2002, which was enacted, and which is a precursor of the RTI Act 2005. Efforts have been made at various state levels as well. Various states have also in the late 90s have tried to instill transparency and accountability in their process of governance. So the states are also the equal stakeholders in this exercise. As far as expression of transparency and accountability is concerned, the two most important words I feel in this RTI Act, Right to Information Act 2005, we also find its mention in the World Bank document on governance and development in 1992 as two of the very important parameters. I'd not like to discuss much of its historical perspective because as far as I understand in the government sphere and especially in academic administration as well, when we deal with lakhs and lakhs of students, the importance and understanding of Right to Information Act and its implementation becomes very easy. And at times we need to also understand that it is not only the section by section knowledge of this act, which is important, but at the same time, we also need to understand that this particular act has to be internalized in the perspective of administrative setup of an institution and how it is best implemented, because every institution will have its own way of functioning, the rules and the regulations, and also the strata of the people they are actually catering to. Therefore, it is important that we understand this particular act in the right perspective and obviously try to also, simulate it in a manner which will fit to the institution where we are working. Because this I am telling because I have got an information that the participants list includes not only the officers from the university, but also officers from other institutions across the country. And I'm very happy that, this kind of an exercise is being undertaken by the university so that, we are getting an opportunity to interact with each other and also get to know and share our knowledge and understanding on this particular platform. Even if it is a 4 weeks training, and I think all the sessions I have seen and they're fantastically prepared, and it touches upon very, very important aspects of academic administration. I repeat the word academic administration because as I have got to know, most of the participants, I think all of them, if I'm not wrong, actually belong to academic administration of the universities or institutions or the national technological institutions and others. Now coming to the relevance of RTI. In so many topics I was just going through, I was thinking that by the name of RTI or Act, this is the only topic which talks about an act. We are not discussing many acts actually in this particular program, or for that matter, any program. It is important, it gains its importance from the fact that this is a functional legislation. Every officer, every employee of an institution must know ABC of the RTI Act to be able to discharge his or her duties in the most objective manner. And but when I say the matter objective is that any day, anytime you get an RTI application requesting for information, you must know what are the provisions under which information can be given or the information cannot be given. So this is a fair background I thought I will say in the process of this before I get into the deliberations, which are like section wise, or to be very honest, the hardcore, the law itself, to the best of my knowledge and understanding. Now, as we understand that the RTI Act has been enacted in the year 2005, and the act came into being on 15th of June 2005, and after 120 days of enactment and its presidential assent, in 12th of October, the entire provisions of the act came into force. Before that, some of the provisions were active actually, and rest of the provisions came into force at a later date. The provisions of section 4.1, section 5.1 and 5.2, which deals with the appointment or designation of the CPIOs and the APIOs, and also section 13, which deals with Information Commission 16, as well as section 27. And rest of the sections of this act came into provision after after 12th of October 2005. Now, when we talk about the basic premise of this RTI Act, now we need to understand this RTI Act emanates from Article 19(1)(a) of the Constitution of India, which talks about the fundamental rights, freedom of speech and expression. So this freedom is ingrained actually in the Constitution of India, and it has been given the shape of an act by the legislature for use by all concerned, by all the public authorities. I require the mouse. I require the mouse. Here. Now, the democratic setup of India envisions constructive participation of the citizens in the process of governance of the country. And Article 19(1)(a), as I told you, is talking about the freedom of speech and expression as a fundamental right. And RTI Act emanates from this particular provision. And the Freedom of Information Act, as I've already mentioned, is actually the primer of this RTI Act 2005. When we talk about the basic premise of this RTI Act, it envisages access to information as a right for the citizens in order to promote transparency and accountability. As I told in the World Bank report also, these two words were the most important words used, and leading to good governance, which is free from corruption and accountable to the governed. The Act also envisages a likely situation of conflict. This is very important. We must understand the Act itself envisages there will be problems in its implementation. Envisages a likely situation of conflict in revelation of information with other public interests, including efficient operations of the governments, optimum use of the limited fiscal resources, and the preservation of confidentiality of sensitive information. Whenever an RTI application is received, I think we hover our thought around these particular areas, that how can we give this much of information? How can you compile this much of information? There is no manpower, so much of resources will be required. So this RTI Act, the preamble of the Act actually envisages all those situations which we discuss in our day-to-day administrative parlance. And on this backdrop, the Act envisages that it is necessary to harmonize. The word is very important. We need to harmonize. That's why I was telling, in any institution you are working, you need to harmonize these provisions with the institutional reality, how you are functioning, and then use the Act in that particular manner. But obviously it has to be used in letter and spirit. So basically this Act envisages it is necessary to harmonize these conflicting interests while preserving the paramountcy of the democratic ideal. So it is the democratic ideal which is the most important aspect of this RTI Act. And in spite of knowing the fact that there will be problems, the Act has been enacted by the Government of India, and this is, I think, the 17th year of its implementation. And if I go by the growth of this particular RTI Act, usage by the citizens, I think this is a people's legislation. I think post-independent India has not seen any act being used by the citizens across the board, I repeat, right from the people who belong to the below poverty line to the highest strata of the society. I have seen people using the RTI Act in a very fruitful manner, very effective manner. Although there may be questions on requests being submitted which are a little problematic to handle. But at the end of the day, we need to also understand that when we have an act, we cannot really check every checkpoint and then provide information. The Act itself is a self-explanatory documentation. It provides all provisions, if used properly. Every information which should be given can be given, and which should not be given also cannot be given. There are provisions of that, so we need to understand that in letter and spirit. Therefore, the Act envisages it's an expedient to provide furnishing certain information to the citizens who deserve it. Please highlight the word certain information. It doesn't talk about providing all information. So one side, the Act talks about the practical regime of right to information. So the word practical is very important. And also it talks about providing certain information. So some information has to be provided. It is not said blanket that every information has to be provided. When we move forward, we will see what kind of information that are required to be provided under the RTI Act and what kind of information which are exempt from disclosure under the RTI Act. Now, on this backdrop, let us understand we are talking about information. So what is information? The Act defines information. The section 2F of the RTI Act defines information. The most important, because it is information on which all the deliberations actually hover around. The information means any material in any form, including records, documents, memos, emails, opinions, and so on and so forth. I'm not reading all of them. You can see it on the screen, and which are held by the public authority, or it is under the control of the public authority. Means even if an information is available with a private authority and you have access to that information in a legal term, that also information is taken as information held under section 2J of the RTI Act. So this is information. And in this definition of information, you will find there is also mention of an expression called opinions. Now, there were little confusion in the earlier days of implementation of the RTI Act when I was also very new as a CPIO. People would seek opinion and use this expression that it is already written that you have to give opinion. Now, it is actually a misnomer. Opinion is not required to be given by reading a document by the CPIO. Rather, if an opinion is already available on the file, like a legal advice or an attorney's advice, and that information is not exempt from disclosure under the RTI Act, such information is required to be provided. Therefore, this opinion is not an opinion after seeing those documents. And there have been DOPT circulars and notifications clarifying this position as well, that the CPIO is not required to do any research. CPIO is the person who is CPIO or the SPIO if it is a public institution under the control of the state authorities, the state government, that is called the State Public Information Officer. CPIO is Central Public Information Officer. So he is not supposed to do any research work on the information requested. Whatever is available, that has to be provided on as is, where is basis. Again, with certain exceptions, we will discuss at a later date. Later part of this, not later date. Now, again, a very important issue comes. What is a record? We talked about information. What is a record? Record is any document, manuscript, file, microfilm, microfiche, facsimile, copy of a document, any reproduction of image or images, or any material available in a computer or in a device. Now, many of us actually do not understand that when we use our computers in office, they are actually a repository of information. And anyone can actually seek information which is available in your computer in a soft form. So that's why when we prepare a letter and keep 10 drafts of that letter available in a computer, all the drafts are actually forming part of information. So one needs to understand also that when we keep on working, as we weed out the official records by observing a very strict weeding out mechanism after a certain period of time. Similarly, unwanted material which are not required at that point of time, we should not crowd our not personal computers, official computers also with such information, because they do fall within the ambit of information. And even if in the file also you keep 10 kinds of documents which are literally unrelated, they also form part of the information. At a later date, after an RTI application is received, if such information is destroyed, it is actually tantamounting to actually destroying the information, and it incurs the provisions of under section 20. We will discuss sometimes later. So we need to understand that also. While I say all these words, it is not to put in your mind any kind of fear, but one thing is very clear, that when we talk about transparency, we talk about accountability, we also talk about objectivity. I personally believe that objective approach and not a subjective approach in our office is the first and the most important thing. And once we follow objectivity in our functioning, I'm sure none of us will see that we face any problem on any RTI application received by us. It is not that we should start thinking after an application is received, what do I do with these records? Rather, we should think a little earlier with whether how the records has to be managed properly in the government documents, government or any public authorities documents. And this is a very important thing. All of us deal with files, and I have interacted with many people. And seldom I have found anybody actually giving a definition of a file. What is a file? Now, file means a collection of papers on a specific subject matter, assigned a file number, and consisting of one or more of the following parts. I repeat, one or more of the following parts: correspondence part, the note sheet part, then the appendix to the correspondence, and the appendix to the notes. Therefore, information which are contained in the file, including the noting portion, also forms part of information as per its definition. There was an understanding at a later date. Now I think things are much more clear, because 17 years is a big time, and I think the public authorities and the officers administering the law, the special law, CPIOs, the first appellate authorities, and also definitely the Information Commission, they have got ample clarity now, and there is a synonymity in its functioning also across the board. What kind of decisions are being given and how they are being used by the people. And I think there is a kind of a synchrony, I'd rather say, in its implementation at this stage, because it's close to 2 decades now, and all of us have learned to live with it in a very nice manner. And we have been using RTI, we have been replying to RTI applications and more seamlessly than ever before. And it is important at the end of the day. Now, what is a public authority? We are talking about public authority. The words which I've used in first 5-7 minutes, I'm just trying to put it in perspective. They're all from the Right to Information Act. Actually, in the section 2, if you go to the definitions, but this is important actually. These are the bricks on which the entire mansion of the Right to Information Act is actually standing. So public authority means any authority or body or institution of self-government established or constituted by or under the Constitution or any other law by the Parliament and state legislature, and notification issued by the appropriate government, and includes body owned, controlled, and substantially financed non-governmental organizations, financed directly or indirectly, and so on and so forth. And this is basically covered under section 2H of the RTI Act. I'm not reading out all the provisions because that will take a little time, and we have got a few things to share with you. Now, what is the right to information? Now, the right to information means the right to information accessible under this act. I repeat, under this act, which is held by or under the control of any public authority and includes the right to, so held by section 2J, any public authority, section 2H. And now comes that what it includes: inspection of the records, documents, taking notes, extracts, certified copies, taking certified samples of the materials. Suppose there is a construction work going on at a place, and somebody visits that and they seek a very small sample of the building material that is being used. That can be provided actually. That forms part of information. That what kind of mortar is being used or anything for that matter. So it can be provided. There are charges for that. The authority may define charges for all these things, like a model or anything like that. So, and obtaining information in the form of diskettes, floppies. I just now told you that in your computer, if something is there, you can provide it in a soft copy also. That also forms part of the information. Somebody may say, can request that provide all the drafts prepared prior to the submission of this letter, which has been issued actually. And if you have kept it, you are duty bound to provide it. So very clear about this. I think I have been telling this to my colleagues on several occasions to keep the records straight, to put our files in a more sanitized manner. I use the word cautiously, that it should be properly maintained. And maybe some other day we discuss about the file management as well, how we are going to do that. But anyways, today is not the day for that. Now the implementation of the RTI Act. Who can seek information? Any citizen of the country can seek this information under section 3. But here we have encountered, I think all of us have encountered this situation that a public authority is seeking information. An NGO is seeking information. Can you provide it? Now you have to understand one thing. Suppose an individual has used a letterhead of an institution and requested for information under the RTI Act. At the end of the application, he has mentioned his name and communication address. Definitely that information has been sought by a citizen. Many times people would ask me that why can't we take action against those people for using the institutional letterhead? So he should not be provided the information. No, according to me, information has to be provided to the citizen, but that citizen, if he is an employee of an institution or a private institution as well, one can always take it up as a complaint against that particular person for misuse of the letterhead, if that person has at all misused it. An action can be taken against him. RTI Act is not the only act in the country which actually operates in isolation. There are other acts and provisions and service rules and everything. So that can be used very easily, but information has to be provided. Just on the garb, if somebody has used a letterhead, so information will not be provided. That is not correct. But if somebody has used a letterhead and at the bottom of the signature, he has written authorized signatory or any designation, general manager, whatever designation, but not his name, then definitely that particular request for information will not be covered under section 3. Because an authorized signatory means that person is representing the institution. So that information is not required to be provided, but section 3 has to be invoked properly and a reasoned decision has to be given by the CPIO or the SPIO as the case may be. And obviously the first appellate authority at a later stage if the institution receives an appeal under section 19. Now, we may talk about the basic processes of seeking information. So I have already covered this part that this enactment of this particular act, the section 5.1 talks about the CPIOs and SPIOs, and also 5.2 talks about the CAPIOs and SAPIOs. APIO is basically a person. There's again a misconception amongst men that APIO is assisting the CPIO in discharge of his duties. This is completely a misplaced conception of this entire provision. CAPIO or the SAPIO is an officer designated by the competent authority of an institution whose responsibility is just to receive the application. That's why Government of India, if I'm not wrong, has made all the post offices across the country, the postmasters or whosoever is the higher authority, as the APIO. So anybody can go to a nearest post office and file an application, and that is be forwarded to the public authority concerned by that particular person. So basically it's an APIO's job they're doing actually. So APIO also is a very important function, and in terms of number of days, 30 days is the maximum number of days one gets, to provide information on receipt of an RT application and request for information in it. And if there is an APIO, so there is another 5 more days is available, because it is taken that 5 days the APIO will take maximum to send the RT application to the concerned CPIO. So that number of days becomes 35 days. So this is a thing which I thought I'd mention. And obviously prescribed fee has to be provided in the proper manner as prescribed under the rules framed under the Act, the rules of 2006, which has later been amended in 2012 as well. And there are a number of decisions of CI's Honorable Central Information Commission, which actually mentions that fee has to be paid in a proper manner as prescribed in the rules. And as we all know that applicants who belong to the below poverty line category are not required to deposit fee under the Act, provided adequate proof of belonging to the BPL category is enclosed. And suppose if somebody is seeking voluminous information not even providing the proper legible, readable copy of the BPL card, the CPIO or the SPIO is well within his or her rights to seek the original document on the basis of which the person is claiming to be in the BPL category. So that is one part. And we talk many times, we encounter RTA applications which talks about non-specific requests for information. Provide the information available in a particular file, all information. Now, all is never defined. There's no boundary for that. So if we go to the section 6.1 of the RTI Act, which I'm not going by section provisions, there is an expression called specific, specifying the request for information. The person has to specify in a particular file what information he needs. Please provide a copy of the service book of an employee. I'm not getting into the legal provisions, but a service book is name of a document. Now, what you need in a service book, leave records you require, that is personal information under section 81J. What information is required? There are information in the service book which still can be provided, but that also needs to be understood that what information the person is seeking. So this is particularly important that key information, request for information is required to be specific. Here on this particular point, I'll just take a little deviation and discuss about the Delhi University's model of implementation of the Right to Information Act. And I think many of institutions are doing that we follow a mechanism of a single window disposal of RTI applications, what has been received, there is one CPIO and one first appellate authority for the entire university, including. Any problems? In the university, and basically the CPIO is the authority who decides the matter on behalf of the university, and also the FA in the same way. Now, the single window mechanism has its own advantages and disadvantages. The biggest advantage of a single window mechanism of disposal or decision on RTI matters is there is a absolute synchrony, and every information which is being provided is actually, if in a particular department information has not been provided, the other department has provided the same set of information. So what happens when this kind of situation arises? The CPIO sitting at the center would know that what is to be done. So the right hand will be knowing what the left hand is doing. So there is absolute synchrony in supply of information to the citizens. And also, yeah.
Like in the, sorry for this.
No.
ये हमारा जो मैकेनिज्म है दिल्ली यूनिवर्सिटी वो हमारी APIO है बात 25 days है. So can we take this to imply that the university has 25 days for the
Very important question. Very, very important question. In fact, even other public authorities also, if they have it. See, basically, we have not designated any officer as our CAPIO, as the history says. But by conduct, the diary and dispatch section and the finance section, which actually encashes the postal orders or the banker's checks for that matter, or online fees, actually are acting as a CAPIOs. But we have not designated them. So if we go by exactly the content of the law in a very dry interpretation, then definitely we will say that no, 30 days only we will get. But I have seen occasions before the Central Information Commission that in course of arguments, because to my understanding, I think I've dealt more than 20,000, is a very conservative figure I'm telling, matters under the RTI Act. And there have been several hundreds of cases were there before the Honorable Central Information Commission. So generally we argue for that and it has been accepted, but there is no mention, I feel, in any particular order that it has been legitimized. But by conduct, definitely they are the APIs. So for sure, that's a very good question actually. And when it comes to a third party information, I'll define third party at a later date, because most of us, in fact, I have found 90% of the officers I interact with will say that an information, this one, no, this cannot be given, this is a third party information. There is a clear demarcation between a third party information under section 11 and personal information as defined under section 81J. And most of us make a hurried mistake or maybe little extrapolation of 81J. So we need to discuss that. I'm just touching upon that because we will come back to this topic a little later. And 40 days when this is a third party information, because 10 days is reserved actually for the seeking a response from the third party and then deciding the matter. And on human rights related matters, it is 45 days. In my entire tenure as a CPIO and the FA of this university for close to a decade, I haven't encountered any application on human rights issues. Third party, definitely a few, but not human rights. So I must say that. Now, an applicant making request for information shall not be required to give any reason for requesting the information. So this is a very, very important provision of this RTI Act. It's a pivot on which the RTI Act stands. No locus standi is required to be proved by that particular citizen. We will come to later stage and you will understand, because section 4 I have not touched, that why he is requesting for this information. No why is required. He is requesting for this information, that's be all and end all, and the public authority is obliged to either provide information or not provide with a specific reason, again by the law. And when an application is made to a public authority requesting for information, what is to be given, which is held by another public authority, and you come to know about it, the 5 days of receipt of the application, it has to be transferred to that another public authority. Again, there is a confusion because here the clause says public authority. And many times you would find in your own knowledge, suppose in University of Delhi, people we talk about, we have got 68 or colleges constituent and affiliated. I don't know whether I'm telling the correct number. I think it is 68 only. And there are colleges which are only affiliated for a few courses. The total number again may go up to 85. But the question is that suppose somebody is asking for all colleges. Are you going to transfer it to 68 colleges? Are you going to transfer it to all our 20 institutions? We need to understand this particular aspect because in the preamble, we have talked about a practical regime of right to information. We have also talked about providing certain information. And we have also known and we have understood that there will be conflict in the situation and we need to harmonize them. So there have been decisions of the Central Information Commission and maybe other authorities, state information commissions also. So generally, it is not the correct way to transfer it to all the public authorities, because it actually generates a lot of rippling effect on the functioning of the government and its institutions. It may be transferred to a few public authorities. Numbers, it is very difficult for me to say from this stage. And this is one important aspect, section 6.3, but it has to be done within 5 days. But suppose in university structure, it happens that the CPIO cannot be a person who is knowing everything on his own. He cannot. So what would happen? The CPIO would be waiting for an input from the concerned deemed PIO. And then that information is to be provided. So even if the CPIO comes to know about it after 10 days, there is no harm in transferring it after 10 days. But the application has to be transferred. So that is one part of it. The single window mechanism has this particular problem, which I was talking about, because the CPIO may not be knowing that this particular information is not available with us or may be available with a particular college. So this particular thing is there when we talk about a single window, but single window mechanism is maximum 99% advantages actually. And I've already explained that a little bit. A public authority to which such application is made shall transfer the application. And I have just talked about this, and I think section 6.3 I have already discussed. Now, information to be provided to the information seeker applicant as expeditiously as possible, but not later than and within 30 days. So 30 days, when you talk about it, is not 30 days actually. 29 day the computer is not working, and we are finding ways and means to tell that why I could not provide that information. We must understand that before the 30th day, there were 29 days. And that information had to be provided in that 29 days also. It is not on the 30th day the onus lies on us actually. So we need to be as quickly providing information as possible. And when we fail to provide information within 30 days, first is that it is actually construed as deemed refusal. The word is deemed refusal. So 31st day you are providing information, basically you have refused to provide the information. You have to justify your point that you are actually providing this information after 30 days. So this is a very important point, and also, there are penal provisions for that all of us mostly know. Here, when we discuss about the CPIO and the SPIO, I'd also like to say, because the single window mechanism we were discussing, so the CPIO has to rely on the deemed PIOs. Now, what are the deemed PIOs? Deemed PIOs are defined under section 5.4 and section 5.5 of the RTA Act. Now, section 5.4 of the RTA Act mentions that the CPIO has the liberty, he has the authority to seek help from a fellow officer in providing the information. And for that particular part of the information, that particular officer is actually acting as a PIO, not the nodal CPIO. This has been introduced from 2009 onwards, from the time I took over as a CPIO of University of Delhi. And the single window mechanism was real-time formalized during that period of time. I'm talking about almost 13-14 years back. And we used to endorse the RTA applications to the concerned deemed PIO invoking section 5.4. And the section 5.5 is a little tricky one, which talks about that if that particular information has not been furnished or some wrong information has been provided, the entire onus lies with the concerned deemed PIO, where the information is held under section 2J of the RTA Act. CPIO has no reason to disbelieve his colleague that that information has been wrongly provided. And for any penal provision to be invoked, it is that particular deemed PIO who has to actually face it, and not the nodal CPIO. This I have been telling in almost all my discussions before our colleagues and others as well, that the deemed PIOs, I think, are the most important persons who are providing the information to the CPIO and facilitating a decision in this regard as early as possible, and obviously within 30 days. Yeah.
Sorry to disturb you, but one candidate is saying he cannot hear you. So, Mr. Apurva Devnath, can you not hear our speaker? Oh, obviously you can't also hear me then. Other participants, can you hear the speaker? Can you please confirm the other participants?
Hello.
Yes.
Can you hear me?
Yes, sir. Yes, sir.
One participant is unable to hear. So can you send a message to that participant? Maybe the voice the Zoom has not been activated.
No.
Yeah.
Now it can be
I can
heard.
wait for 30 seconds, doesn't matter.
Yeah, I'll have to type it from here.
Yeah, please.
We're doing it. All right, so yeah, everyone has confirmed and we've asked Mr. Devnath to join again.
Okay, fine. So now under section 6.1, information is sought and information is provided under section 7.1. I'm not going into the details of it. Please read the RTI Act, the BEAR Act. It provides every information in the most simplest of the term. I'm just touching upon a few provisions which are functionally important for working as a CPIO or the deemed PIO or the first appellate authority of an institution. It's not moving. And information shall ordinarily be provided.
सर कुछ प्रेजेंट कर रहे हैं तो सर वो दिखाई नहीं दे रहा है.
How about others? दूसरे लोग देख पा रहे हैं क्या?
जी दिखाई दे रहा है मैडम.
यस मैम, सामने दिख रहा है.
Yes, ma'am. Yes.
ठीक है, तो जिनको
It's visible.
ये एन इन्फॉर्मेशन शेल ये आ गया ना, सामने है एन इन्फॉर्मेशन शेल ऑर्डिनरी.
जिनको नहीं दिख रहा है, दोबारा ज्वाइन करें प्लीज.
Slide title basic process.
ओके ओके
संस्कृति जी, आप दोबारा ज्वाइन करिए.
ठीक है मैम, थैंक यू.
Okay, ma'am. Thank you so much.
So an information shall ordinarily be provided in the form in which it is sought unless it would disproportionately divert the resources and detrimental to the safety or preservation of the record. This talks about those age-old manuscripts, old documents which have become brittle over a period of time. And if somebody is seeking an information, you want to make a photocopy and the document gets destroyed. So in that case, inspection is a better mode of actually providing that information. The person can come and inspect the document. And if it is physically not possible to give a copy, that the person can inspect it and see the document. That's what it is all about. And under section 7.9 would also cover a very important part. Suppose a person is seeking information from your organization about the number of employees whose date of birth is on 1st of January. Information which is definitely held by us, by any public authority, because service book has date of birth of all the employees. Do we think that suppose an institution has 5,000 employees, then they are immediately employing 2-3 people to just scan through the service books and find out whose date of birth is 1st of January, and then make a tabular information, then deduce it, and then provide to the appellant or the applicant for that matter? It is not required. It is not required because it will disproportionately divert the resources of the public authority. So one may very politely mention, this is my interpretation of the law, obviously I must say, and I've used it on several occasions, that the information requested by the appellant or the applicant is not maintained. There is a difference between not available and not maintained. Many of our deemed PIOs I've seen will plainly mention information is not available. Wrong. The information is available, but it is not maintained in the manner requested by the applicant. And one may say that the compilation of the information would disproportionately divert the resources of the public authority, which is not required under the Act. And if such information, suppose 1st of January, whose date of birth is certainly not serving any larger public interest. Again, a very important benchmark of providing information under the RTI Act. So if it does not seem to, actually create a larger public interest, then that also has to be mentioned. And you can also mention that for the day-to-day functioning of your section, of your office, of your branch, you don't need to keep such information in indexed and catalog manner. And then you may say, therefore, such information cannot be provided. However, if the applicant specifies a particular request or a particular one or two people, that can be considered. But considered, one may not say that shall be given, because it might happen that also invokes certain other clauses. So this is the way we can address a few tricky situations under the RTI Act. Now, there's a clarification. This is not a clarification. This is basically that research thing which I mentioned, that the CPIO is not required to do any research work actually. Here it is coming a little late. I have already discussed about it. The deemed PIO also have discussed. Let me read the section 5.5. Very interesting. Any officer whose assistance has been sought under section 4, subsection 4, shall render all assistance. Here the word is all assistance. This is not the word some assistance. All assistance to the CPIO or the SPIO, as the case may be, seeking his or her assistance, and for the purposes of any contravention of the provisions of this act, such other officer shall be treated as the CPIO or the SPIO, as the case may be. So this is a very, very important provision when a single window mechanism is actually activated. So it is more difficult actually to an extent for the deemed PIO, because he has to really take a call on the issues which are under his or her active control, and the information is held or not held for some reason. Now, what kind of information is exempt from disclosure under the RTI Act? There's a section 8.1, and from section 8.1a to section 8.1j, various information, categories of information has been listed which are exempt from disclosure. And this definitely include, I'll not get into the detail of it. Again, you can get it in the bare act, and it is just a reproduction of that to an extent. May not be word by word, just giving an example of the things. Matters related to sovereignty, integrity, security, strategic affairs, scientific, economic interests. So this is 8.1a. And now similarly, information expressly forbidden by any court of law to be, or tribunal, or for disclosure, non-disclosure, then disclosure of which would cause a breach of privilege of the parliament or the state legislature, that is 8.1c. And obviously 8.1d, you may encounter information including commercial confidence, trade secrets, or intellectual property, the disclosure of which would harm the competitive position of a third party, unless the competent authority is satisfied that larger public interest warrants the disclosure of such information. In a purchase process through tenders, this is definitely a clause which one may think of using. I think you can mute on. Then a very important provision comes: information available to a person in his fiduciary relationship unless the competent authority is satisfied the larger public interest warrants the disclosure of such information, as per section 8.1e. It talks about a fiduciary relationship, a relationship of trust, a relationship of between a lawyer and its client, or maybe a doctor and a patient, and something like that. It has been derived from a Latin word fiduciary, which means trust. So therefore, the word fiduciary means law involving trust, and especially with regard to the relationship between a trustee and a beneficiary. So definitely 8.1e has to be invoked on matters where the information is held by a public authority in trust of the employee concerned. Exemptions are there under section 8.1f, confidence about foreign government information. Then disclosure section 8.1g is very important for the public authorities like the academic institutions, which deals with the examinations and other processes, where the names of the evaluators, superintendents, and the people actively associated with the examination are not to be disclosed under this clause under 8.1g, which talks about disclosure which would endanger the life or the physical safety or any person, or identify the source of information. Such information is exempt from disclosure under section 8.1g. So that's why when we provide information under disclosure of evaluated answer scripts norms, the answer script to a particular student of his or her own answer script, evaluated answer script, definitely the names and the other details of the evaluator and superintendent, and every detail is actually masked under section 10. That is a clause of severance. We'll discuss it at a later time. And there is a case, I have mentioned about it, but I think I've discussed it far superiorly. on that. And this is a classic case, with decision of the Honorable Supreme Court of India and the Civil Appeal number 6454 in 2011, the case of CBSE and another versus Aditya Bandyopadhyay and others, where it was held that the identity of the examiners, coordinators, scrutinizers, and everything are exempt from disclosure under Section 81G. So this is a very important decision. Then comes the information about investigations and prosecution of offenders, Section 81H. Even the disciplinary inquiries and other investigations in our offices are covered by this Section 818 during the currency of the inquiry process. And if some request is received during this period of time, then the CPIO may simply invoke this 81H and also can mention one thing, in that a particular applicant may seek the same information through the established procedure of the inquiry proceedings, where he has a definitive right to get that information. And obviously, after that comes the Section 81I, those cabinet papers and all that, which we are not much concerned about. And then comes the information, which is very important. I was talking about Section 81J, information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual, unless the CPI or the SPIO or the appellate authority, as the case may be, satisfied that the larger public interest justifies the disclosure of such information. I'd like to highlight a very important point here. In various other provisions, we talk about the competent authority, the competent government to take decisions, this and that. But here, you see the entire onus of defining an information as personal rests with the CPI or the SPIO or the first or the appellate authority. And this has been respected even in a decision of the Honorable Supreme Court of India in the GR Deshpande matter. The citation is available. And in that also some information, it was said that such information is exempt from disclosure, but it has given an authority to the CPIO not to be actually swayed by this decision. The CPIO or the SPIO has to go case by case and see whether that information has to be provided or not, keeping in mind the larger public interest issue as well. So this is a very important provision where the CPIO or the SPIO or the appellate authority has to decide the matter in a very cautious and careful manner before terming an information as 81J personal information. And obviously it talks about exemptions, which talk about, permissible according substitute, or public authority may allow access to information if public interest in disclosure outweighs the harm to be protected to the protected interest. So obviously the larger public interest is there. So we are talking about that. Exemptions are also there on other things. I'm not getting into all the details of it. There is a 20-year clause actually. So most of us are familiar with that. And I'm just talking about this, the Honorable Supreme Court of India, SLPC number 27734 of 2012 in GR Deshpande versus CIC and others has held that the income tax returns, information about movable and immovable property, etc., are treated as personal information of the employee concerned as per Section 81J of that. But however, the CPO or the SPIO can consider disclosure of such information in a given case if the CPO or the SPIO is satisfied that larger public interest justifies the disclosure of such information. So one can easily imagine the authority that has been vested in an officer to how he should decide the matter. Many of us at times really do not give importance, but this is a very, very important provision. I do not see our CPIO in this particular program. Is he a participant here? He must be available online. Okay, fine. But he has not responded. But anyway, it doesn't matter. The exemption under Section 8 of the Act are in consonance with the Article 19(2) of the Constitution of India, because it envisages reasonable restriction even on the freedom of speech and expression. And so therefore, there's no harm that there are certain expressions, certain information which are not to be provided. And then Section 9 talks about access to information on infringement of copyright subsisting in a person. But generally, when it comes to a state, the copyright in a state, so that I think that is of not much of value for us. Now, the applicability of the doctrine of severability, this is very important. This is very important because many times some information will be sought in a particular matter. Part of the information can be given, part of the information cannot be given. And the CPI is in a dilemma what to do. Very clear doctrine of severability. It talks about if after severing the information which cannot be given, you sever that information out of 100, suppose you sever 50% of it, and the rest of the 50% which can be given carries a reasonable meaning. It cannot be a meaningless piece of some letters or sentences you are providing. If it carries an independent meaning on that particular part which can be disclosed, then the CPIO has to invoke the clause under which that not provided information falls, and also mention about section 10(1) and sever that part of the information and provide the rest of the information. It's very much within the framework of the law. Many times we come across people who talk about that see the half of the information cannot be provided, and other half how can I provide? So there's a clear understanding of section 10 talks about that. And then I'm talking about the third party information. The third party information is an information which has been given by a third party to a public authority, treating that information as a confidential. I'll not say the word confidential because it does not feature anywhere in the RTI Act. So basically it intends to disclose an information if CPIO decides that I won't disclose this information or part thereof on a request under this act, and which relates to or has been supplied by a third party and has been treated as confidential by the third party. It has been treated by that third party as confidential. So then the CPIO or the SPIO, as the case may be, within 5 days of receipt of this request, will send a written notice to the third party that he intends to provide this information and whether the observation of the third party. But the observation of the third party is to be taken note of by the CPIO, but it is not binding on the CPIO that if the third party has said that do not provide this information and CPIO goes by that, I am now safe because the third party has protected me, that this information cannot be provided, so I cannot provide. No, third party, even if third party says do not provide this information, CPIO still has to justify why this information cannot be provided. So on many occasions, I have seen CPIOs, I will not name anybody on this particular platform, instead of using third-party information or section 11, they actually use section 8(1)(j), where actually the CPIO becomes a competent authority to decide whether this information has to be given or not, because the baggage of another individual along with that, at every stage, the third party has to be given a notice. At every stage, the third party has to be taken into consideration till the second appeal stage or even further. So basically, many times CPIOs have used this avenue of actually choosing to not provide information under section 8(1)(j) and not invoking section 11. Some of the people, it's not across the board. So do not generalize my.
Please keep some time for you.
Yeah.
Will have questions.
Yeah, definitely. I will just finish it up very fast. And I'm not going into the details of it. These are actually the provisions of this act. The first appeal is obviously section 19(1). Within 30 days, of receipt of the decision of the CPIO, a first appeal can be preferred before the first appellate authority. And the CPIO's decision must mention at the bottom of it the details of the first appellate authority and also this particular clause of within 30 days that person has to submit the first appeal. The second appeal is basically till 90 days of the receipt of the decision of the FAA, that is a first appellate authority. But these 30 days and the 90 days, these can be actually, given relaxation by the concerned authorities if they are satisfied that that such kind of appeals could not be filed before because of certain reasonable grounds, and that's why, so even after 30 days or even after 90 days, as the case may be, appeals can be filed, but that has to be accepted by the respected authority. And if the respected authority does not accept that, so no question lies with that, it has to be deliberated. Again, these are the provisions of the section 19, the second appeal. I'm not getting into the detail. And there is section 18 of the RTI Act, which talks about complaints. In a complaint, the difference is that in a complaint, when somebody has put an RTI application and then a decision has been given by the CPIO or the SPIO, or not given by the CPIO and SPIO, and the person, instead of going on an appeal, goes for a complaint directly before the concerned SIC or the CIC, as it may be. Can we say the person to?
Someone's microphone is on. Mr. Upendra Paswan ji.
Okay, so section 18 talks about the complaint, and when the complaint is being dealt, then there is no need of any first appeal or any second appeal. So directly the CPIO has to actually defend the complaint before the SIC or the CIC. So I'm just briefly telling, because these are all written very clearly. Slides are not moving. And these are the penal provisions. I think this I don't need to discuss in detail because all of us have known this provision, and this is the reason that RTI is, according to me, this is one of the reasons that RTI is given importance by almost everybody. No, that is none. That would have given a very wrong impression. Even I'm not going to discuss this provision as well, because this is basically the question of nullified, and the CPI or the SPIO or the concerned deemed PIO has to justify before the Honorable Commission he or she has acted in highest good faith and there is no nullified. The onus lies with the concerned officer. So obviously there is a there's a burden of proof actually. And you understand that that is the reason that this provision section 20 subclause 1, and then the disciplinary action thing, if it is section 20 subclause 2 where somebody is an habitual offender, you know, so action can be taken under the respective service rules as recommended by the CIC or the SICs. So this is one part of this RTI Act we discussed. Can you just allow me to move the slide, please? So this is section 22. I'm not getting into the details of it. One can read and understand. Now the protection of action taken, I think all the miscellaneous provisions under this part from section 21 to section 31, these are provisions where action is taken on a good faith. So this is a very important provision that generally it is taken that action is taken on good faith. And then section 22, which talks about a non-obstant clause as usual, talks about the act to have overriding effect. Section 20.
इसके नाम लिखा आ रहा है कौन है? प्रज्वाल जी, we have to exit you from here. Please, आप देखिए आपके यहाँ पे कुछ पेन ऑन है. It seems you're sketching something inadvertently. कौन है प्रज्वाल जी? Is he not in the list? No, I can't see him here.
So this is section 22, which talks about the basically the overriding effect of this RTI Act, and then section 23 talk about the bar of jurisdiction of the courts, because everything has to be decided through within the framework of this Act and through appeal procedures thereafter. Section 24 talks about also the Act will not apply to certain organizations relating to national security, intelligence, and something like that. And there are as many as, according to my information, 26 such institutions have already been listed. There it may be more than that because I may not have the latest data also, but it was 26 in 2016 as I have known. Then there's section 25 talking about the monitoring and reporting on the matters of implementation of the RTI Act by the state information commissions as well as the central information commission to the government. Section 26 talks about appropriate government to prepare programs so that to enlighten the people as well as its officers about the RTI Act and its importance and its implementation. Section 27 talks about the power to make rules by the appropriate government, state government for the state authorities, central government for the central authorities, and as well as other appropriate authorities like the governor generals, the lieutenant governors of the UTs and other authorities, obviously. Section 28 talks about the power to make rules by the competent authority. That is this one I mentioned. And section 29 talks about the laying of the rules before the parliament or the state legislature, and section 30, power to remove difficulties, and section 31 is repeal of the Freedom of Information Act 2002. So these are the sections which are coming under the miscellaneous provision, and these are miscellaneous provisions are part of the part 6. Actually, the RTI Act has got 6 parts. This is under the miscellaneous provisions. Now, very quickly, I will touch upon a very important area. I'll take maximum 5 minutes to say that whatever we discussed till now was talking about a particular functional part of the RTI Act. Can you just take it on your hand, because he's not looking at me actually. And every time I've been telling him that. Now, these obligations of the public authorities. This is basically a very, very important position. And I think this is the heart and soul of the RTI Act, according to me. This is actually forming part of the chapter 2, right to information and obligations of the public authorities. And section 4.1, very important, every public authority shall maintain all its records duly catalogued and indexed. I'm not reading the entire document. Go back to the preamble. It talks about a practical regime. Definitely in 1 day or 10 days, it cannot be done, but it has to be a continuous exercise, because every day, every public authority generates so much of information. It has to be indexed and cataloged, and it has to be put in the public domain. Section 4.1 has got 4.1a talks about that, and 4.1b talks about as many as 17 manuals with detailing the institutional structure, its function, its procedures, and everything one can think of within the ambit of functioning of the institution. I repeat, everything. If you read the 17 manuals and then prepare an information handbook, which will be annually, at least annually, it should be updated and it will be put in the public domain. It is a mandatory responsibility, and the head of the institution is actually responsible for this kind of updation, as well as providing information in the public domain from time to time. And when we talk about the head of the institution, obviously the head of the institution is actually assisted by a battery of officers who would be actually discharging their duties assigned to them and will be able to do this exercise possible. It requires a humongous effort from all the officers who are working on various departments and offices, and they need to put this particular thing in their mind. Whatever work they are doing, they will have a bearing on the section 4.1b, and these are called the proactive disclosures. And if a public authority is able to disclose information as delineated in section 4.1b, the number of applications requesting for information will be 10s to 0. Using a mathematical terminology, it will be 10s to 0, because every information is otherwise available in the public domain. So the discretions, why should I give, how should I give, these all the whys and the hows will actually vanish in a second. So basically, this is the RTI Act. Section 4.1b, if you implement properly, then in fact, the section 4 in totality, then most of the issues are being addressed. Talks about section 4.1c, you see, publish all relevant facts, formulating important policies and announcing the decisions which affect the public at large. Universities do that. Students are affected in big number. And section 4.1d talks about reasons for administrative and quasi-judicial decisions. You give reasons. You give reasons in your own press releases, in your own documentation to why this has been done. So nobody will put a question back, why this particular thing has been done, which is to our disadvantage. People would be knowing actually. So even our office orders, notifications, circulars, every document has to be a speaking order. It must say what transpired to take the decision by the public authority. It cannot be a separate addendum going as an explanation or explanatory note to a notification. So formulation of a notification, I keep telling my colleagues, whenever you formulate a notification, an office order is to be self-contained. By the word self-contained, I mean it must contain every possible information that a person not acquainted with that subject matter would read and understand. The lucid language, appropriate reference to the rules, as well as a systematic procedure of putting it one by one will make an office order effective. And most of the time you will see that there will be no questions on that, because people will be knowing what the reason is. Even there is a question, you can refer to the website or give a copy of the order and not describe the order in its own way. Section 4.2 is again very important. It talks about what I've just now said. It shall be a constant endeavor of every public authority to take steps in accordance with the requirements of clause B of subsection A, that is 4.1b, to provide as much information suo motu, that is on your own, to the public domain at regular intervals through various means of communications, including internet, so that the public have minimum resort to the use of this act to obtain information. So when you have got maximum information in the public domain, the section 6.1, then all section 7.1, the section 8, and everything just vanish, those appeal procedures. So the entire bandwagon of the particular implementation machinery actually is not required, or required at a bare minimum level. I must not say not, because still there will be something left out. These are all provisions under section 4. And this is talking about the Public Records Act. I may not mention about this because this is basically maintenance of public records properly, and it is very akin to section 4.1a of the RTI Act. But it requires actually a designation of a public records officer also by the public authority. And various provisions of obligations I've already mentioned in detail to the extent I could do within this limited period of time. So this is what actually the RTI Act is all about and its implementation. And I really would like to thank all of you for, patiently hearing me. I don't know whether I have been able to, provide any information which is useful, but I did try my best. Sure.
Thank you. Yeah, questions, yeah, please.
Sometimes तो ऐसा होता है कि RTI में जैसे मैंने पढ़ा था कि आप 90 years की information नहीं दे सकते, ऐसा कहीं मैंने पढ़ा।
कितने दिन का?
More than 19
अच्छा।
19 साल। But sometimes we are receiving the request from the candidate seeking information more than 20 years, 25 years.
Okay, I'll answer you. If the information is, I'm not again naming the public authority, a public authority was requested to provide an information which was as old as 359 years old. And the public authority's record said that the information was not destroyed. So that public authority is duty bound to provide that information or give an affidavit that the information is not traceable, or it has got unintentionally destroyed, or it is not retrievable. I repeat the word retrievable. No, again, I'll come back to this very important point we have put forward. In fact, this Aditya Bandyopadhyay case which we are talking about, about disclosure of evaluated answer script. Many people, when I talk about this particular historic decision of the Honorable Supreme Court of India on RTI, and for the first time, they have dissected a few provisions of this law. If you read that particular judgment, I'm sure it is written in such a lucid English that everybody will understand the essence of the law. In fact, to be very honest, I think in 2011, I was also a little naive in this particular, even today I'm a naive. I'm learning every day on RTI. It's an ever learning subject. And you would be surprised that in that it is written that answer script, keeping the answer scripts, 50 lakh copies, 40 lakh copies, you don't have a space. But you cannot say that I will not provide it. You mentioned that how many days you are going to keep that copy of the evaluated answer script with you. Define the record retention schedule again. Many of the public authorities you go and ask, do you have a document which clearly defines the delegation of power and authority in every respect for every post? And number two, in administration, do you have a clearly defined record retention schedule? Most of us would encounter, we don't have, we are in the process of preparing it.
Sometimes a single person.
I'm telling you, I have not completed. So if you have a record retention schedule of 2 years and you have destroyed the document after 2 years, then you are not duty bound to provide. But if your records say that record retention schedule is for 2 years, but you have no record of destruction of that information, then you have to provide it. Mere mention, इतना था आपने हिंदी में बोला, मैं हिंदी में जवाब देता हूं, तो मैं नहीं दूंगा. No, ऐसा नहीं. You have to still provide that information if you have not actually weeded out that record.
Sometimes I guess there is a frequently information for 10 times, 11 times, 20 years.
That's why the section 4 is important. You put it in the public domain. No? The moment you see on a particular matter, information is being requested by the mass level from the citizens, and you are continuously replying to that and getting titanized in the process. I repeat the word, getting titanized actually. Same information. Why can't a mechanism be developed and put the information in the public domain? Let me tell you one very close example of it, which I have done it actually. Delhi University's financial estimates were put in the public domain in the year 2009. Before that, I don't want to mention what was the position. It was in the public domain. The annual report is in the public domain. The audit report is in the public domain. The decisions of the executive council and the academic council are in the public domain. People told that, what about the disciplinary matters? The simple answer is you simply say disciplinary matter and just, block that particular part of it. But that does not stop providing the rest of the information on the garb of it. So our website is now, these days, you can see how much information we are providing in the public domain. And I think it has got a tremendous effect on, controlling these day-to-day RT applications. I think one former CPI is with us sitting there, successfully handled this, in a very difficult time, I must say. And Madam Meenakshi Sahai, she is right here. And we have seen actually that the moment you see certain information is being sought repeatedly, put it in the public domain. That's the best way. If not, we have understood, we have diagnosed properly, but at least after the thing has come forward to us, at least we should. There's no harm. secrecy has no place in the government after the, this Secrecy Act, this has gone. The norm is to provide information. The norm is to provide information. So whenever you get a request, which I generally do, I see what information I can give and not what information I will not give. Right. So that approach, a glass half empty, half full. Right.
One more thing, sir.
Yeah, sure.
You have already said the section invokes to derive information, but also the ability which information will be considered as
Okay, let me tell you one thing. Just give you an example. Somebody has gotten information about your salary. Now, whether it is a personal information, what is your total emoluments? I use the word correctly now. What is your total emoluments? By your name only, giving your name, my name. What is the total emoluments of Mr. Joy Chandra, Indian University as a joint registrar? It is a public information because I'm a public functionary. But the moment the citizen asks, provide me the net emoluments after deduction, that is personal information. Because how much amount I put on my general provident fund, how much amount I put on my insurance policies, that is not a public information. The total emoluments actually forms part of one of the manual, I think manual 11 or 12. We have already put it in the public domain in a very intelligent manner with a formula actually, with the pay scale. I think Meenakshi would second it. We've done that in a very intelligent manner. It has been actually applauded by the CIC also. Yeah. So giving an example to you. So what is personal, what is not? A bit of a rationality of thought and also 17 years of experience under this law would give us a sufficient cue. This cue is CUE, not QUE. A sufficient cue that what we should provide, what we should not. And but one thing is for sure is that one needs to be reasonable. And what is the definition of reasonable is very difficult to say. These reasonable restrictions. No, when you say an information personal, no. See what happens. I have seen people doing that. I think other public authorities are also facing it. Some dim PI is telling this information is personal, but you have to justify that. Why this information is personal? See, provident fund of a person is actually what? It is his bank account. Can you go to a bank and say that the list of account holders details, passbook photocopy you provide? Similarly, something like that. I've seen in this system, GPF statements at the end of the 1 year goes in a pad, little pad. And now it comes to you in a sealed lifafa. Who has done it? Because it's a personal information. You have to sensitize your finance officer, of your colleagues in the finance, that this is actually a personal information, a very, very important personal information. Disclosure of the balance in the GPF is tantamounting to actually you are disclosing his bank details. You are actually making the man vulnerable under section 81G. Forget about the J. So you have ramifications. So that's why the understanding of the law is very important. But law cannot be understood in an island concept. Most of us try to do that actually. Look at RTI in an island. Don't look at it as an island concept. Look at it as a part of your daily deliberations. And get it naturalized into it. And it really is not a law one should be really thinking about. In fact, having required to have a session on RTI, the moment such training programs and these discussions will take it out, that day we will know that it has got internalized. It has got imbibed into the public system in a very seamless manner. So this is what is important. Any further questions?
We have participants who want to ask you questions.
Yeah, sure.
Ramesh ji, आप सवाल पूछिए please.
सर नमस्कार सर.
नमस्कार.
सर मेरा क्वेश्चन ये था, थर्ड पार्टी इंफॉर्मेशन पे हम लोग जैसे किसी का, जैसे एक एप्लीकेंट अपने कोलिग्स का ही इंफॉर्मेशन मांग रहा है, तो वो क्या हम थर्ड पार्टी में कंसिडर कर सकते हैं?
आप कर सकते हैं. देखिए, मैंने आपको पहले भी बताया है कि थर्ड पार्टी ऑफ इंफॉर्मेशन जब आप करते हैं तो कई CPIOs के मन में ऐसा रहता है कि मैंने जब भी किसी को थर्ड पार्टी बनाया और उसने बोला मेरा इंफॉर्मेशन मत दो और मैंने उसकी बात को मान लिया तो मैं प्रोटेक्टेड हो गया. ये दिमाग से निकाल दे बस.
Okay.
अगर उसने मना करने के लिए बोला लेकिन आप भी उसके बात पे आके मना कर दिया और बाद में पाया गया कि उस सूचना दिया जा सकता था क्योंकि
Okay.
तो उसके बाद आप ये नहीं आर्गुमेंट कर सकते सीआईसी के सामने या एसआईसी के सामने या एपेलेट अथॉरिटी के सामने आपके इंस्टीट्यूशन का कि मैंने तो थर्ड पार्टी की बातें मान के ऐसा किया था।
Okay.
थर्ड पार्टी जो है वो एक सिटीजन है फॉर द पर्पस ऑफ यू, वो इंपॉर्टेंट होता है। इसीलिए कई सीपीआईओस जो क्या करते हैं, थर्ड पार्टी इन्वोक करके 10 दिन तो लेना होता है। और एक बात और भी हो जाता है, थोड़ा इनफॉर्मली बता रहा हूं, मतलब ये हम लोग
Yes, sir.
डिस्कशन कर ही रहे हैं। कई बार
हाँ जी।
थर्ड पार्टी अगर हॉस्टाइल हो जाए, जिन्होंने सूचना मांगा था और थर्ड पार्टी में उस समय में कुछ इश्यूज थे, बाद में दैट गॉट रिजॉल्व व्हिच यू डू नॉट नो, and later on they try to hop off. That becomes also a difficult part at some times. I'm not going to give any specific example. So वो भी एक issue रहता है, but third party you should definitely invoke, no problem. But only
Yes, sir.
that at the first appeal stage you have to give notice, at the second appeal stage there will be notice, and you have to take along the third party. There's no harm. This is a wonderful provision of third party. It gives a little leeway to the CPIO also to take a decision, but that submission of the third party is not final and binding. I repeat, final and binding on the CPI or the SPI. He has to take the decision on his own.
One more query, sir, regarding third party only.
Yeah.
Whether that information which we are seeking from third party should be given to the applicant as a copy?
No, certainly not. Your decision is self-contained.
Okay.
The question of giving it to the third party just does not arise.
Okay. ठीक sir.
Third party's information, actually, whatever you give, that is with you. Actually, whatever is between you and the third party.
Okay.
You give your own decision.
Okay, sir. Okay. Thank you.
GD Somji, आप पूछिए।
Sir, it is applicable all over India.
Yeah.
All over India, sir.
Yeah.
Kashmir.
What? I couldn't get it.
Kashmir, I think.
Yeah. It is. I think it is all over India.
All over India, sir.
Yeah.
Okay, sir. Okay, sir. Thank you, sir.
Okay, Virender Singh जी, पूछिए आप अपना सवाल।
Sir, can you clarify more about? There was one point in your slide regarding to some inquiry.
Okay.
If there is some inquiries going
Section
on.
818. Section 818. See what happens many a times when there's an ongoing inquiry, including matters of where there's a case of sexual harassment in the workplace. There will be uneasy situations because suddenly you get an RTI application and what information can be given. Now for the sexual harassment matters, when it comes on RTI, you must mention the specific clause. I'm just not remembering offhand. There's a law for that, I think in 2013, and in that there's a section, I think section 16, if I'm not wrong, but just check with the particular law, which actually exempts disclosure of such information in the public domain. So 81J to hai hi hai, 81H to hai hi hai. In fact, after that, you can, before that law came into force, I used to use actually a combination of 81E, 81H as also 81J. And I used to mention about the modesty of a woman in the entire exercise. Although it is not written anywhere in the law, but as I say, it is a process of naturalization of this law. When we read the law, we also need to understand that we are working in a practical regime of right to information, and certain information has to be provided as per the preamble of this law.
If the this inquiry is of a general nature, not of this kind.
Okay, in general nature inquiry also, during the currency of the inquiry, you are not supposed to provide any information under section 81H, and you may also guide that particular person. You see, many times what happens, we reply in such a manner as if, like is the end of it actually. So one may always mention that you go to the inquiry proceeding processes under the inquiry proceeding and obtain such information which are otherwise required to be provided to you. Otherwise, it will jeopardize the inquiry process actually, because the inquiry process also provides various information to the accused person as well as others who are associated with it, and it has quite a democratic process being followed.
So if the inquiry is going on and the RTI is asking for the status of that inquiry.
No, you are not supposed to provide the status. If it is not complete, you will always say that the matter is under process and no finality arrived at. Yeah, definitely.
Right.
See, I must tell you one thing. A classic example. Examiner's name or evaluator's name cannot be provided under RTI Act. So a student seeks an information, giving a name, whether this person was an evaluator in this entire examination process. Not his answer script or her answer script.
I think that is also, sir, mentioned in one of the.
No.
decisions in the Supreme Court.
Let me finish. What would be the correct answer according to me? Is that to simply say the information which cannot be disclosed overtly can also not be disclosed overtly by a roundabout question. So you cannot even confirm that that person was actually a person who was actually an evaluator in the exercise. Even if you say he was an evaluator, you have already put him under Section 81G breach. So one has to handle such matters in a little, intelligent manner.
Yes.
People definitely ask such questions and off guard, Just giving an example, just before a day of the examination, you get an RTI under RTI application, maybe 2 days before, under life and liberty. Please provide a copy of the question paper, which will be the question paper for the next examination. It is an information because the question paper has been formulated. There is a question paper. Now, how the examination will be conducted? What do you do say? Somebody has asked this information. Section 81D will come because it talks about competitive position of a third party. Now, if you only get that information, rest is not getting, so your competitive position increases. An examining body cannot do that. So Section 81D has to be invoked. Now, CPI, somebody is telling about that, why can't we give that information? Definitely we can give. But Section 81D का violation हो जाएगा फिर. एग्जाम से पहले भी क्वेश्चन पेपर मांगने में क्या प्रॉब्लम है? आप 10 रुपए का आरटीआई देके किसी को आप हाथ थोड़े रोक सकते हैं. मंडे को एग्जाम है, शुक्रवार को शाम को 3:30 बजे उन्होंने एक आरटीआई आपके दफ्तर में डाला और उसमें आपने बोला कि सोमवार की एग्जामिनेशन का क्वेश्चन पेपर दीजिए. तो आपको तो उसका डिसीजन तो देना पड़ेगा ना 48 घंटे में. इवन आप मना भी कर रहे हैं. एनएन कालिया वर्सेस पीआईओ यूनिवर्सिटी ऑफ दिल्ली के एक डिसीजन है सितंबर 2009 का, जिसके अंदर ऐसा तो नहीं, लेकिन एक डिसीजन सीआईसी ने अपहोल्ड किया था, एक कंप्लेंट था एक्चुअली, एंड दैट कंप्लेंट डिड नॉट हैव एनी हियरिंग एक्चुअली. And there is a landmark judgment by Honorable former Information Commissioner Mr. Sailesh Gandhi on that particular matter, where he has defined life and liberty, which is a proviso to Section 7(1), and in very, very clear terms, what life and liberty actually means in the context of this transparency law, where actually somebody's life is at stake. The life is at stake biologically. It does not come into that on a Monday, as somebody says on a Friday that the date sheet is wrong, so Monday's examination of cancel kar dijiye. You can't do that in a public system. So there will be people who will be doing that. There will be a 0.1001% people who would be looking at it this way, but that does not demean the law or the essence of this law in any way. It is one of the finest legislations post-independent India has ever seen, and how it has been used actually by the citizens across the board, I have said. It has instilled tremendous transparency and accountability in the governance, according to my understanding.
Sir?
जी, अब अगर किसी का कोई, I don't think there are any more questions. I can't see hand. क्या किसी का सवाल है और?
सर, क्या प्राइवेट इंस्टीट्यूशंस और सेक्टर्स भी आरटीआई के अंतर्गत आते हैं क्या?
बहुत ही जनरलाइज्ड क्वेश्चन किया आपने. अगर उस पब्लिक प्राइवेट इंस्टीट्यूशन ने जो जमीन लिया है वो 1 रुपए में लिया है, 100 एकड़ का जमीन, तो डेफिनेटली वो पब्लिक अथॉरिटी में आएगा. कोई भी कंसेशन लिया है गवर्नमेंट से, कोई भी कंसेशन उस इंस्टीट्यूशन को चलाने के लिए वो बिल्कुल आएगा.
नहीं, अगर सर कोई रजिस्टर्ड है और उसमें कोई कंसेशन नहीं लिया है, जैसे मान लीजिए कुछ कोचिंग इंस्टीट्यूशंस होते हैं जो कि गवर्नमेंट
नहीं आएगा, बिल्कुल नहीं आएगा, बिल्कुल नहीं. पब्लिक अथॉरिटी के डेफिनेशन में बताया गया ना कि आपके इंफॉर्मेशन हेल्ड कहां पे है. एक तो आपके पास हेल्ड है एज ए पब्लिक अथॉरिटी और अंडर योर कंट्रोल. ऑब्वियसली आप किसी कोचिंग इंस्टीट्यूशन को तो कोई टेंडर दिए नहीं होंगे कि हमारे पेपर बनवा दीजिए, तो नहीं आएंगे उसके अंदर, तो डेफिनेटली नहीं आते हैं. बट हाँ, अगर थोड़ा सा भी कहीं पे भी कोई बेनिफिट लिया है तो उसमें जरूर आते हैं. एनजीओ से लेकर
that also includes the grants.
Definitely, why not grants? Grants are definitely part of it.
For example, the UGC grants.
Yeah, definitely. That's directly associated, sir.
सर, मेरा एक क्वेरी है, एम्प्लॉय और एम्प्लॉयर के बीच में जो इंफॉर्मेशन होती है, उसको किस तरह से, कुछ मैंने एक सीएससी का जजमेंट पढ़ा था जिसमें बोला था कि एम्प्लॉय अपने एम्प्लॉयर से इंफॉर्मेशन सीख करना गलत है, मतलब ठीक नहीं है, क्योंकि वो अपना ग्रीवेंस के थ्रू कर सकता है. इस पे थोड़ा हाईलाइट करेंगे सर आप?
कई केसेस मन में आते हैं, बट एनीवेज केस स्पेसिफिक बात ना करें. प्रश्न इस बात का है कि आरटीआई हर सिटीजन के लिए है, एम्प्लॉय भी एक सिटीजन ही है. आरटीआई एक्ट में एम्प्लॉय और एम्प्लॉयर का रिलेशनशिप डिफाइंड नहीं किया गया है. बहुत ही सादा और सुंदर तरीके से बताया गया है कि सिटीजन और पब्लिक अथॉरिटी। तो एक एम्प्लॉय अगर सिटीजन है तो सिटीजन का राइट वो जरूर इस्तेमाल कर सकते हैं, हाँ, लेकिन एक ही विषय पे 500 आरटीआई डालना या उसके ऊपर कोई सवाल जवाब करते रहना या कई बार ऐसे प्रश्न को उठाना बार बार करके जिसका जवाब दिया जा चुका है, तो उसके निदान तो आरटीआई एक्ट के अंदर ही होगा, क्योंकि आप सेक्शन 23 में चले जाएं, फिर उसी अपील प्रोसीडियर से होगा। सीआईसी एक ओवरऑल सिचुएशन को लेते हुए डेफिनेटली उसके ऊपर कोई जजमेंट अपने डिसीजन पास कर सकते हैं, बट सीपीआईओ लेवल पे या एफए लेवल पे तो वो संभव नहीं है कि उनको हम मना कर दें। अगर सिटीजन ने 10 रुपए देके आरटीआई एक एप्लीकेशन रजिस्टर किया है तो उसका जवाब तो देना पड़ेगा। वो तो एग्जेम्पशन में नहीं आ सकते कि वो मेरा एम्प्लॉय है और मुझे हैरेस कर रहे हैं,
ठीक सर,
बट हाँ, तो वो तो नहीं कर सकते।
थैंक यू सर, थैंक यू।
I don't think there are any more questions now. So I think we can safely conclude this session. Let me quickly thank our speaker for the day. So thank you so much, Mr. Chanda, for a rather informative, I would say, and a power-packed with a lot of information. I was thinking all this while, thank God, and no point in time I have to deal with all this. So I think it was quite a lot of information. And yes, and of course, thank you for being very detailed in your answers to the participants as well as during the course of the presentation. Thank you so much.
Namaskar. Namaskar.
Thank you.